The 3 minor children spent significantly more time with dad during his days off. With mom's proposed schedule, on the other hand, the children will spend significantly less time with dad. And upon dad's belief, the true reason behind the request is based upon mom's boyfriend's parenting schedule with his children rather than the fact about what's in these children's best interest.
Court will note the appearance of Ms. Thomas on behalf of the plaintiff, Ms. McNiff on behalf of defendant. This matter is before the court on the defendant's motion to modify parenting time and other relief. Ms. McNiff.
Your Honor, I would know that this case was filed in April. I believe that the party signed a judgment of divorce in May, although it isn't dated, so I'm not completely clear. However, it looks like front of the court approved it in June. These parties never worked under a temporary order. They went straight from filing to signing a judgment of divorce. In the interim, in the last 4 or 5 months, my client has come to realize that the schedule that they agreed to, she does not believe is serving the best interests of the children. The schedule currently revolves around dad's schedule because he's a firefighter and he has 4 days off, 5 days on. And while it seems like that would be simple to put into a schedule, it's actually very difficult because it's not an alternating week schedule. It takes my client a great deal of time to input it. She's asked him to put it into our family wizard, which the parties are utilizing, and that simply hasn't happened. She has to schedule all of her work around his schedule, which makes it very complicated for her. And while the response was, well, they've been doing this for years, she understands it. Also, they were a family unit at that point, and it was a little bit easier when you had combined extended family to help with the children. At this point, having done this schedule as a separated couple, my client has found that it's been cumbersome for her, it's been cumbersome for the children. It's difficult for the children to remember what days they're with dad, what days they're with mom. She believes going to an alternating week schedule would simply cut out all of that confusion. It would make it easier for her to schedule her work hours, and it would be easier for the children to remember which house they're supposed to be out at when. In addition, there's issues with the parent, with the holiday schedule, because it doesn't really accommodate the fact that both of these parties, due to their jobs, can be scheduled for to work on a holiday. And so we're asking for really as a minor adjustment, which would say that assign a holiday to a particular parent, as we normally do, a standard holiday schedule, but with the provision that in the event that that parent has to work on the holiday, the other parent would have the holiday, and the parent who was assigned the holiday would get first pick of a makeup parenting time, which just seems like it would be a reasonable accommodation given the fact that these parties don't have 9 to 5 jobs Monday through Friday. We're also concerned that it seems that whenever my client brings up issues on our family wizard or on a prior app that the parties were using to communicate, she simply gets shut down. She's tried to make these talk about these accommodations and these changes directly with dad. Dad simply shuts down and won't discuss them. So I understand it's a bit of an odd request, but it's also a bit of an odd situation when the parties so quickly entered into a judgment of divorce and there's no temporary order to change. And there's no order to change, in fact, at this point, because the judgment hasn't been entered, it's only been signed. But we are asking for those minor changes.
Okay, Ms. Thomas, response?
Your Honor, we disagree with Ms. McNiff's position. We believe that the issues in this matter have been resolved. The parties participated in mediation with Mr. Brundage. They worked with Attorney Podolsky, who is a family friend, regarding the consent judgment of divorce, including making changes and revisions prior to signing the final judgment of divorce. They signed a uniform child support order. Those consent orders, along with a judgment information form, was submitted to the front of the court, who has in fact approved the judgment of divorce and uniform child support order. And this matter is actually set for a pro-confessor hearing 2 weeks from today. These parties worked together extensively, reviewed work schedules, and meticulously set forth a parenting schedule that they believe was not only in their children's best interest, allowing the children the maximum time with each of their parents. It was a schedule that children are familiar with and accustomed to, as throughout their lives, the 3 minor children spent significantly more time with dad during his days off. With mom's proposed schedule, on the other hand, the children will spend significantly less time with dad. And upon dad's belief, the true reason behind the request is based upon mom's boyfriend's parenting schedule with his children rather than the fact about what's in these children's best interest. This is the same schedule that has gone on throughout the marriage. The fact that it's too confusing or difficult to work around is disingenuous. Dad's schedule is very typical for a firefighter. Mom's schedule is not all that atypical for a nurse midwife. Although presenting dad's work schedule as difficult to work around, it has been worked around by hundreds and hundreds of families with firefighters, including mom throughout this marriage. And in the city of Marshall, there has not been recurring changes. In fact, no changes to said schedule in over 10 years. And shy of there being a change in the city policy, dad has a schedule from now until when the youngest child will be 18. So that it's not as though mom doesn't know. She's always known what that schedule is. It's 5 and 4. He works every other day during the 5, and then he has 4 days off. It's always been that way. With that schedule and his paid time off, dad ends up working 8 days per month. Mom, on the other hand, typically works 2 8-hour shifts and tries to stack her 2 required hospital shifts back to back as a 24-hour shift. Mom does have flexibility in her shifts, and she's able to stack by far the majority of her hospital time. It was workable schedule when mom was not only working part-time, she was watching the children. She was also getting her master's degree at U of M. So this is a workable schedule. It's been worked around since the time that the parties have been together. Mom's proposed week on, week off parenting time would also result in dad having to incur 25-hour childcare during each of his shifts. Although mom alleges that she has difficulties with childcare, some of that is likely her own doing, but beyond that, she has made free use of her boyfriend as a childcare provider during the pendency of this marriage, of this matter, who she allows to parent her children for the convenience of her schedule. Plus, both dad's parents and mom's parents and their extended family are willing to assist with caring for the children as necessary. There's also Marley School has aftercare school program for the children that they can attend, or they can ride the bus to dad's house for mom to pick them up there. Honestly, the plaintiff contends that other than surviving in this and serving her own interests, there is no reason to change the agreed upon parenting schedule. It is a parenting schedule that the parties agreed upon as being in their children's best interests. It is the schedule set forth in the judgment of divorce that both parties have signed, and mom's reason to change, again, is disingenuous. As stated in Kaiser v. Kaiser 182 Mishap 268, it is well settled that with regard to both written agreements and settlements placed verbally on the record, parties to a divorce action are bound by their settlement agreements in the absence of fraud, duress, or mutual mistake. None of that has been claimed here. In the case at bar, both parties signed the proposed judgment of divorce after having extensive negotiations regarding their settlement agreement and talking both freely and completely with Ms. Podolsky. According to the Massachusetts Indemnity Life Insurance Company v. Thomas 206 Mishap 265, a settlement agreement such as a stipulation in property settlement and divorce is construed as a contract. Interpretation of unambiguous and unequivocal contract language is a question of law. We believe that in this particular case, the parties entered into a settlement agreement or a contract as to the issues before this court and are asking that the court can uphold that contract. And if for some reason this court deems that that agreement should not be upheld, then obviously require mom to show proper cause or change in circumstances, as it is a contract at this point. Moreover, and although it wasn't argued today, the defendant was asking for specifically our family wizard and had to have contact when if dad takes the children on a state that mom needs to know in advance. Also in this case, there was a letter between Ms. McNiff and Ms. Podolsky from Ms. McNiff that specifically stated that the defendant was happy with the agreement. And so to now claim it's cumbersome is, again, we believe that's disingenuous. We're asking that the court actually uphold the judgment of divorce as it's stated. And because we're supposed to be back in 2 weeks anyway, allow a pro-confessal hearing to be actually done today and be done with this matter in 2 weeks when the time would have run, if it hasn't run already, when the time would have run, and let this divorce be completed.
I would just say that Shade versus Wright permits parenting time changes under any ordinary life circumstance changes.
Okay. Well, when a court, I've heard the argument, I've read the pleadings in this matter as well. The court doesn't find that there's a basis to modify the parenting time that the parties had just only recently agreed to and signed. So the court's going to deny that motion. I will order that the parties would communicate through our family wizard, which apparently they've been doing. So that will be the order of the court. I'll ask Ms. McNiff, it's your motion, you can prepare that order and submit it under 7 days.
Well,
Your Honor, with that in mind, can we do a pro-con real quick? So we don't have to come back in 2 weeks?
Well,
We only have one more 9:30.
okay, we had a lot, we lost a couple of the 9:30. I'll let you take the pro-con in this particular matter, so.
Okay, if my client can be sworn, I'm ready.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give shall be the whole truth and nothing but the truth?
I do.
Go ahead, Ms. Thomas.
Okay, thank you. Mr. Holly, do you recall signing a complaint for divorce?
I do.
At the time that you signed that complaint, were all the statements in the complaint truthful?
They were.
Are they still truthful today?
Yes.
To the best of your knowledge, is your wife pregnant?
No.
You had indicated in your complaint for divorce that there had been a breakdown of the marital relationship to the extent the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Is that correct?
Yes.
Can you please briefly describe to the court what caused the breakdown?
The defendant's infidelity.
Is there any possibility if the judge were to not sign the judgment of divorce that's been proposed that you could reconcile your differences and again live together as husband and wife?
No.
May it please the court?
Court is satisfied the testimony does establish the statutory basis. There has been a showing there's been a breakdown of the marital relationship. The court will, in fact, preserve the proofs at this time pending receipt of the paperwork. So you're free to go today. Good luck to you. And the matter will be complete when the court signs that paperwork, which may just be a few days. So have a good day.
Thank you, Your Honor.